is a pre-need guardian, and why would I need one if I have a power of attorney and healthcare surrogate already in place? Well, it's a bit of a complex question, but here's the answer. In the state of Florida, the guardianship law is relatively clear that a guardianship is only necessary if it is the last resort or the least intrusive means of providing assistance in making legal, medical, financial decisions for someone who has lost capacity. So if you have a really well-drafted power of attorney and healthcare surrogates like that come in our document set, it makes it less likely that you will need a guardianship in the future. However, in my career, I have had several occasions where even with great powers of attorney and healthcare surrogate documents, and even with great agents that we have appointed that are doing a good job for us, there are times where a guardianship is still necessary. Sometimes that happens when our clients suffer with dementia. And sometimes with dementia comes an unfortunate sidecar of paranoia, of uncooperativeness. And so there have been times where dad is driving every day and his driving skill set has gotten less than optimal. And he's starting to bump into things and people and really be unsafe on the road. So the power of attorney agent is like, hey, dad, or hey, spouse, it's probably time for you to hang up your keys and stop driving. And of course, the client says, you're not taking my keys away and I'll do what I want. And you're not going to stop me. And they really become a danger to themselves and other people. So there are times where we do need judicial intervention to kind of force the right thing to be done when the client, through their own loss of capacity, and just generally getting old and cranky, don't want to follow instructions, and they're putting themselves or other people in jeopardy. So one of the reasons I like having the pre-need guardian is that the state of Florida statutes allow you to choose your own guardian. And what that does is puts you in control of that decision. Many people choose the same people as their power of attorney or healthcare surrogate agent. But what it prevents, which is very important, it prevents the judge sitting in guardianship court from just taking the easy route and just appointing the next professional guardian off the rotation and putting them in charge of you. And this is a person who's never met you, knows nothing about your personal preferences, your cultural or religious beliefs, and you effectively just become a number to them. And I don't know about you, but if it was me or my family member, I would want to have control over who's legally in charge of me and not just put it up to some stranger who I've never met, who I might not have chosen if I had the option. So always best practice to have a pre-need guardianship for you. And even though most general estate planners don't give you that document, I think it is a key document in our set of advanced directives with the elder law and asset protection language in it.